Afternoon, everywhere that it matters at least. We've now crossed that line. So we'll introduce ourselves again and then want to hear who you are, where you're from, and also introduce your teacher as well. I am Lieutenant Colonel Kurt Mabus. I am an attorney with the United States Air Force. I'm currently in Colorado Springs, Colorado, and I teach law at the Air Force Academy. Richard.
My name is Richard Leiter. I'm professor of law and director of the law library at the University of Nebraska College of Law here in Lincoln, Nebraska. I've been judging state competitions for about 15 years, and this is my first time at the Nationals. Happy to be here.
Canada, you're muted.
Thank you. My name is Candida Steele, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country, and until Friday was with Maryland, but I've just moved to Maine as of the weekend. So I look forward to hearing all of you. It's a little further from New Jersey than I used to be, but good to see you all.
Over to y'all.
Hi, my name is Minta Sauna. I'm a senior at East Brunswick High School.
Hi, my name is Abby Portnoy, and I'm also a senior at East Brunswick High School.
Hi, my name is Raina Fanous, and I'm also a senior at East Brunswick High School.
Hi, my name is Lara Petrutis. I'm also a senior at East Brunswick High School, and this is our teacher, Mark Mondry.
Good afternoon.
Good afternoon and welcome all. That was nice of you to have trouble with your mute to make our judge feel a little bit better. So well done.
I feel much better.
All right, folks, we're here, Unit 5. We're going to do question number 1. So I'll read question number 1 and then turn it over for your response. A result of the decision in Wisconsin v. Yoder is that any parent guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with the result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights? Over to you.
We agree with the result of Wisconsin v. Yoder because it correctly protected free exercise and maintained the strict scrutiny standard established in Sherbert v. Werner. The court ruled correctly because the Amish demonstrated a sincerely held religious belief, while Wisconsin was unable to provide a narrowly tailored, compelling government interest. The Amish belief is sincerely held because they have active members and they're an identifiable religious sect. While Wisconsin's interest in creating individuals that are self-reliant and self-sufficient is apparent, the Amish themselves proved to be a truly self-reliant community. We also agree with Professor Jack Rakoff that the Amish alternative suits the real lives they would lead as adults and through learning by doing. We also find that while there is merit in Justice Douglas's dissent, we agree with the majority opinion that the parents were not preventing their students from attending school against their expressed desires.
All 50 U.S. states recognize the right to an education within their state constitutions. 8 states secure the people the advantages and opportunities of education, confirming it as a positive right. Also, 11 states, including New Jersey, use the words thorough and efficient in their education clauses. In the New Jersey Supreme Court case of Abbott v. Burke II, these words were interpreted to mean a level of education as will enable all students to function as citizens and workers in the same society. Furthermore, 8 states require equal state funding and similar term lengths to fulfill a general and uniform education.
While the Constitution fails to explicitly identify the right to education, we believe it is a fundamental right under the 9th and 14th Amendments. Despite being a minority opinion not recognized by the Supreme Court, we concur with Justice Marshall's dissent in San Antonio v. Rodriguez that the nation has a historical dedication to education and should be constitutionally protected. Education satisfies the Washington v. Glucksberg fundamental rights test, which evaluates whether a right is deeply rooted in our nation's history and is implicit to the concept of ordered liberty. While we recognize that the founders did not include education in the Bill of Rights, in 1787, Jefferson wrote that the education of the common people should be attended to, demonstrated that education is deeply rooted in our nation's history. The Sixth Circuit Court recognized education as a fundamental right in Gary B. v. Whitmer by applying the test and asserting that access to literacy is so central to our political and social systems that it should be implicit in the concept of ordered liberty.
In balancing religion with other rights, courts evaluate the sincerity of a belief, the neutrality of a law, the strength of a government interest, and if the law is narrowly tailored. Courts favored combating drug use over religious rights in Employment Division v. Smith, where Oregon's refusal to provide unemployment compensation was upheld after the petitioners were fired for ingesting peyote at a religious ceremony, lowering the religious exemption standard from strict scrutiny to rational basis review. The court held free exercise does not excuse an individual with compliance with an otherwise valid law. Following Smith, the Religious Freedom Restoration Act reinstated strict scrutiny. This was applied in Hobby Lobby v. Burwell, where the court ruled a private company's religious beliefs outweighed the government interest of guaranteeing access to specific contraceptive methods in the Affordable Care Act. Also, in the COVID-19 pandemic, courts have balanced public health with religious rights, as seen in Roman Catholic Diocese v. Cuomo.
All right, excellent. So many questions, so many questions. So where should I start? At the beginning, all right, you come out of the gate and you say that you agree with Yoder, but then the next couple of authorities you cite say that education is deeply rooted, that you agree with the dissent in San Antonio, Texas v. Rodriguez, and that it has to be level to function as a citizen. That's your own constitution. Make those work for me. Yoder said it wasn't important. You're saying it is important and you agree with Yoder.
I think it's important to make the distinction that in Yoder, Wisconsin said that their compelling government interest in education was to cultivate a self-reliant and self-sufficient community. And as proved by scholars such as Dr. Donald Erickson, who said that the Amish really are a self-sufficient community within themselves, and that their vocational alternative, which is learning through doing, prepares them for their adulthood and allows them to succeed in our society.
Furthermore, I think that while education clearly has this strong value, the compulsory attendance in Wisconsin is not necessarily the best way to provide education. The goal of education is to provide for adulthood and all of these things, and that can be done without explicitly requiring those students to go to school for those 2 years.
Okay. Well, what do you think the separation of church and state mean?
I think that separation of church and state means that the state really has no place regulating religion and endorsing any religion. And we see the separation of church and state in the Lemon Test, which prohibits endorsement and establishment by the government.
I think it's also an important distinction that it's not just one religion over the other, but non-religious over religious. And it's important that the students who are religious are able to access their religion and are not burdened by the state. For example, if we look at Utah, Mormon students are allowed to leave in order to attend religious ceremonies during school time and then come back. This way, students who are not religious are able to continue with their school, but the more religious students are able to participate in religious education during that time period.
Well, so how do we determine the student's interest versus the parent's interest in this question?
So I think we're referring to really refers to the dissent proposed by Justice Douglas. And in looking at this, the court we can look back to Pierce versus the Society of the Sisters, in which the court affirmed that the parents do really have the role of being able to decide where their children go. And while that case was just more so between like public and private education, I still think that that standard can apply in this case, and that the parents do have that responsibility to be able to choose the type of education and even the religion. And as the court stated, there was no real clear case or clear facts that these children were being forced to do this against their beliefs.
Adding on to that, these children also have the option to return to school after if they decide that they do not want to be a part of the Amish community after they have received their other alternative education, the Amish's vocational alternative.
Okay, back to Minta's answer there. How do you determine when the child's right becomes strong enough to be at odds with the parents? Is there a standard that we can use?
I think that I believe it's up to the age of 16 that parents really do have this role of deciding their child's educational path. And we see that in Wisconsin v. Yoder. And we also see that in cases like Meyer v. Nebraska, where the parents really can determine what their children should be doing and where their education lies. And as Lara said, specifically in the Amish community, these Amish children take a lot of supplementary classes after their high school education in order to fulfill whatever career they want to have if they weren't able to do that through their Amish alternative of education.
Yeah, and while I agree with what Abby said and what I was discussing earlier, I can see the merit in what Justice Douglas was saying, and that I think that his opinion was also largely based off of Tinker v. Des Moines, which happened just a few years before that case, where the court recognized that the students in that case do have those First Amendment rights and should be protected even within the schoolhouse gates.
Well, speaking of tests, you mentioned two tests in your opening, both the strict scrutiny test in Yoder and then Smith, the minimum scrutiny or the rational basis. Which one is the right test to apply in free exercise clause questions?
I think the strict scrutiny standard is the right one to apply. And we see, if we look at Employment Division v. Smith versus the decision in Gonzalez v. UDV, where in Employment Division v. Smith, the use of peyote was, I guess, above religious exercise because they used the rational basis review. However, in Gonzalez v. UDV, free exercise was ruled to, I guess, supersede the use of or the prohibition of ayahuasca. And we see that strict scrutiny really does uphold religion and provide the correct basis for religious exemptions as opposed to rational basis review.
Also, following the decision of Employment Division, we see the RFRA was established during that time period, which brings it back to strict scrutiny and makes it so that religion is held at a higher standard.
Yeah, going off. Oh, sorry.
No, go for it.
Going off of what Verena was saying, that the importance of the RFRA is in the sense that like the Congress is basically saying that the courts kind of got it wrong in Employment v. Division, and the people think that like it should be this higher standard. Freedom of religion is included in the First Amendment for a reason. It is one of our most important values, and many of the people coming to our nation in the beginning came for that religious freedom, and it should be held to the highest level of protection.
Okay, so speaking of freedom of religion, then, do you think the government can or should assist parochial schools? Financially or otherwise?
Well, in our own town, we actually have Hatikva, which is a charter school, but it is also focuses a lot with like Hebrew immersion. And so while this is a largely, in a sense, it's kind of a religious school, almost posing as like this public school because it receives that financial aid. And I think in that case, scenario, that it should just become like a more of a private school where there is that like clear separation and no like state support of it.
Going off of what Minta.
Congratulations. Great job.
Yeah.
Really great job.
I'll take the lead here. I think that you all should be very proud of yourselves. You demonstrated a depth of knowledge about these matters that is really impressive. And it isn't, I have the sense in hearing your responses to our questions, your opening statement, that it wasn't simply book knowledge. You just didn't read about this and were prepared for a test, but you understood it and you're conversant in the language of the law. And constitutional law is tricky, and it involves a lot of logic and a lot of background in order to talk about it. And you did. I was very impressed. You should all be very proud of yourselves. Thank you.
Yeah, I'll echo that a lot, because I don't know how you felt when you first saw the question, and if you thought, oh, I don't know if this is going to be a very fun one to talk about, but there's so much going on right now where this can apply, and you brought us to the current events, Hobby Lobby, and even some of the pandemic cases. So well done linking it all the way through, because it seems like this is old law. But there's a lot going on with this one, and you did a wonderful job of both advocating your position as well as relying on authority and precedent to make your point. So great job there. Thank you very much.
I agree with my colleagues. I think you did a wonderful job discussing the fundamental rights, and you just did a really thorough, clear, balanced review of this question and brought in all kinds of information. Thank you. It was really lovely to listen to. And I just really want you to, you all seem enthused, and I hope that the experience has bitten you in some fashion, that it will keep you reading the paper and finding out what's going on in the world, and talking to your friends and colleagues and parents and friends, and getting people in to vote, and especially going and voting yourselves the rest of your lives, because you'll understand how important it is. But I think you also have shown that not only are you going to be wonderful citizens, but if you're interested, you certainly have the potential to represent the rest of us in local, state, and federal positions, because we need people who have the understanding and this understanding of the subtlety of the role of government in a complex society. And I'd be happy to vote for any one of you. So I will be very happy sitting in my rocking chair in a nursing home knowing that your generation has taken over, if they know as much as you all do. So thank you. You certainly know more than my law school class knew.
And I'd be certainly happy to have any one of you in my class.
Great. Thank you so much. It's a wonderful job.
Good job.